Good afternoon. Welcome. Thank you. Lots of familiar faces out there, so thank you all for making it. And I'd like to tell all those people who told me last night at 1 a.m. they were going to be here, they can all go to hell. Anyway, should be a subject of much controversy and discussion during these tales. Something that I brought up last year and going to go much into depth today, which is the idea of intellectual property and how it relates to our industry. Mostly looking at from a bartender's point of view, but I think this subject certainly touches upon people of all creative medias, the media in particular, and the members of the media stuck in the back. I'd like to thank them for coming in as well. What we're going to do today is talk about intellectual property, and helping me out with the technical aspects, and certainly more thorough than I am, is Lagesen and Sheila Morrison from Davis Wright Tremaine out in Portland, Oregon. I met Riley a little over a year ago when I was in the need of a lawyer to figure out how to start making negotiations with companies. And Riley I got in contact with through Audrey, and he had been working with Ryan McGarian and other people in the industry and really understood our perspective on how to broker deals more than anyone else. Riley is now the chair of the National Restaurant Practice Group for the firm, and working with a number of people and celebrity chefs as well in brokering deals. And I encourage you all to go to the next seminar, which is going to be just that, how to broker a deal, that Riley's going to be involved in. And fortunately, Sheila was kind enough to join us in this conversation as well, because she is the chair of the trademark department, knows a little bit more about, in particular, what we're talking about today. So we have a lot of content to cover today, so we're going to try and move quickly. I'm going to pass it over to Sheila in just a minute, who is going to sort of define intellectual property for us all. And then we're going to go in sort of a scenario where I'm going to bring up experiences that I have that hopefully reflect ones that you have and address most of our concerns. And then we will try and be good to leave time at the end of the session for questions from everyone else. During this, we are going to be having a 4-martini lunch. And you're going to be served 4 different martinis. Remember which one came first and which one came last, because each martini is different. I can give you the base ingredient and thank my sponsors at the same time, which is going to be Absolute and Plymouth Gin. But at the end, I'm going to ask for the person who can break down what the matrix is on all of those martinis and what's going on in each one, and whoever is wise enough and has a delicate enough palate at 12:30 to do this will win a one of these Absolute kit bags, which you can throw all the bar tools out and put your computer here if you like in a little while. So I'd like to thank Ang and Tales of the Cocktail for having me down. Of course, again, my sponsors. And I really want to thank Riley and Sheila for coming and sharing their knowledge with us, because I think this is really an immediate concern for all people. And as you'll see in my conclusion at the end, the whole point of this is trying to educate the community on how to protect ourselves and maybe better profit from this cocktail revolution we are all so fortunate to be a part of. So with no more from me, Sheila, please.
Thanks, Evan. Can everybody hear me okay? I usually don't have a problem with that, so. Microphones, probably no microphones. What I'm going to do at the beginning of this presentation is just talk about what intellectual property is, or the technical meaning. Intellectual property is a concept and a term that's used pretty regularly in sort of day-to-day language, but it does have, from a legal perspective, a certain meaning. It's actually a web or 4 different buckets of rights that are some based on federal law, some based on state law. And I think once we go through that, you understand sort of the problem that there's a challenge facing the industry about how to protect what it is that you do. So I want to go through that to set the stage, and I think it'll be helpful. What is intellectual property? When you think about it from the perspective of layman's terms, it's about invention, it's about goodwill, how do I protect my name? It's about creativity and protecting that creativity, and it's about protecting know-how. So these are all things that you create by the sweat of your brow, by your talent, and intellectual property is the moniker that is used to protect it. But what each of those things really correlates to is an area of the law. There's patents, trademarks, copyright, and trade secret. If what you're doing doesn't fall into one of those 4 buckets, it's probably not protected by the law, and we'll talk a little bit about what you do in that situation. A patent, as many of you may know, it's really a monopoly. It's a very strong protection, but they're given, it's given to an inventor for a certain period of time, and it's really about creating a situation where people want to invent and create things. It's about shifting the cost of R&D, and if you invent something, you create something, you can then be the only one to use it or exploit it and ultimately get your R&D costs and some profit back. In the case of patents, it really doesn't apply to the cocktail space unless you're talking about an apparatus. Here's some examples for those of you into the tiki world. These are from Trader Vic's. Those were patented swizzle sticks, which I think are very cool because my husband's family spent a lot of time at Trader Vic's in the old days. So I had to put it in there. It may be a method. So if you have a method for extracting flavor from something that theoretically could be patentable, and it's worth looking at. Patents, however, are expensive, and the threshold for protection is very high. It has to be new, it has to be useful, and it has to be non-obvious. And by non-obvious, that really means that it can't be. It has to be a pretty significant jump in innovation. That's pretty hard in the cocktail space, so it's not an area that we'll really focus on today. Most of you are familiar with trademarks and brands. For years now, in the cocktail space, the brands are very important. Obviously, the liquor brands are important. And you've probably heard recently that there are sort of back and forth about whether or not branding of cocktails themselves really makes sense. There was a fight recently about the Dark and Stormy brand cocktail. Here, this is something that I think is a struggle within the industry about what to brand. You know, do I brand my cocktail so I can protect it if I can't protect it in other ways? And I think that's sometimes that's appropriate. You can also have a trademark or brand, not only your name itself, your personal name, but if you come up with a stage name or something like that, it's also something that where trademarks might help. Where it becomes challenging is you don't want it to become absurd. Sometimes, you know, trying to order, from a consumer's perspective, you're trying to order a Dark and Stormy, and whether it has Gosling's rum may not matter to you, creates a problem. So there's a little bit of a challenge with trademarks, but it really is about identifying the goodwill and it functions as a symbol. The other area of copyright, or the other area of intellectual property, the third bucket, as I like to call them, is copyright. Copyright protects actual expression of ideas, not the ideas itself. It works for paintings and novels and even in software. If you have a pen and you put it to paper or you type on a keyboard, those are all things that are protected by copyright. But it's only to the extent that somebody cuts and pastes. So it's the copying of the actual material. Copyright absolutely is very clear, it does not protect recipes. So any attempt to register or own a copyright for recipes is going to fail because it's just explicit. It says it on the copyright.gov website. They are not protected because they're considered just a mere listing of ingredients. So what that means is when you are creative and do come up with new cocktail recipes, you need to find another way to protect them, and we're going to talk a little bit about that. One thing that you should know, however, on copyright is to the extent that you have directions for methods or information, history, descriptions that relate to a cocktail that you've written down, again, that's prose, that's protected under copyright. And if you have something that's really important and you don't want somebody to cut and paste, then you should probably register that material, which gives lots of opportunities to enforce. And we'll talk a little bit about that too.
If I can just interject some direction, you have a twist and an olive in front of you. You may use them at will, however you see fit. With the Edward of the 4 martinis, you would.
Excuse me, I took that opportunity to taste, sorry. I love my work. The next bucket of intellectual property protection is trade secrets. Now this is an area that I think is underutilized in the cocktail space, but something that should be considered. If you have something, this is kind of a catch-all. If you have something that is protectable or that you want to protect that doesn't fall into patents and it doesn't fall into trademarks and doesn't fall into copyright, keep it secret and you can own it as a trade secret. There are some things you have to do though, is you have to keep it secret. Publishing it is not going to help you. You need to also, if you are going to let people know what's in the recipe or you have a secret sauce, so to speak, If you're going to let your other bartenders know, if you're going to let people know so they can make the drinks too, so it's not you slaving behind the bar forever and ever, you need to do so when there's a confidential relationship, and that means a contract. There needs to be some sort of understanding, some duty on the part of the person to whom you disclose the information that they can't sell it or use it without permission. As a corollary, this is the kind of thing that a lot of folks in the food business do. The ingredients on the package of a set of cookies, for example, you have to lay out all the ingredients. There's nothing secret about what's in a food product. Spice packets, that's how they do it. They make sure that there's certain spices or flavorings for the food product, even if it's a tiny little incremental amount compared to the rest of the product, they keep that secret. The recipe for Coke, nobody knows. So you might take a hint from that aspect of food business when you're looking for ways to build a fence around what it is you're creating.
Sheila, sorry, does that mean you would suggest if there was a bar owner who was making their own bitters, their own tinctures, their own syrups, all those things behind the bar, if you wanted to protect that, you would need for all of your bartenders working behind the bar to sign something that says that that is your property, because just by letting them use those products and recipe, you're sort of sacrificing that to that employee, correct?
Well, if they're using the product, if they're using it in recipe, that's okay, because they don't know how it's made. But if you're instructing them and showing them how to make them, then
right.
Yes, you want them to be under contract. You want them to have an agreement that says that is your property.
Okay.
And that's the most customary way to do it, is to sign non-disclosure agreements with employees. We recommend when you're hiring somebody as an owner of an establishment that in the employment agreement or whatever other contractual relationship you might have with the employee contains a non-disclosure provision in there. Trade secrets, you're supposed to take reasonable efforts to maintain secrecy. Having a contract is pretty reasonable, so that's what we typically recommend doing. Sometimes it's a little awkward when you have an employee there and you have them sign something. Well, why am I signing this? That's why outside of employment, it's often a convenient time to do that. But if you're not taking reasonable efforts to maintain secrecy and it becomes an issue that's subject to dispute, and they can show that you let people have this information rather carelessly, you might lose that trade secret protection.
That's right.
Sorry, I see there's a couple questions. I'm afraid because we have so much content, we're going to try and barrel through it. So we are going to leave a question and answer at the end. So I'm sorry to make you wait, but it's just that we have a ton of content to cover, which I'm already taking up too much time.